David Clark.
Mr Chair, I am very sorry to see Mr Robertson cut short, being limited to only 4 speeches in this part of the bill.
No long speeches.
Cut down in his prime, but I'm sure there'll be another opportunity, maybe in the title and commencement, to finish the argument that he was developing. Mr Chair, I didn't have the privilege of sitting through the committee on this particular bill, although I notice, and the questions I will bring up relate to previous editions of a very similar bill, because a very similar bill gets put through this House every year, tidying up a number of these same issues, and that is a good thing. And I want to say something very positive from the opposition benches about this bill. This is a necessary and important thing, and I hope that those listening at home or watching on the TV can see that there's also a very constructive thing going on here, where opposition members are drawing attention to concerns about the bill, which is designed to patch up where there are loopholes. This Part 3 of the bill is tidying up the Act to make sure it achieves the purpose that it is set down to achieve. And so when my colleagues pick some holes in it, they're actually doing the government a favour, because there's an opportunity for SOPs, supplementary order papers, to amend the bill, to tidy up any little things that come to light through this part of the debate. And so my questions are in a similar vein, and the Minister and the Chair, I'm sure, can get himself briefed if the answers aren't not immediately to mind. Firstly, I want to just talk about Clause 69B, which talks about the exceptions for overseas accommodation. And I am wondering what level of discussion was had that settled on the subclause A and B definitions of what should be included in this aspect of the Act around the costs of accommodation. So subclause A says that for the purposes of this subsection, the actual cost to the employee of the accommodation, or B, a reasonable estimate of the expenditure that is likely to be incurred by the employee or group of employees for whom the amount is payable. When this debate has been had in the past, there has been a debate around what constitutes accommodation for the purposes of work, and what constitutes accommodation that goes above and beyond that. So the nature of accommodation. So if somebody is going to do a simple job fixing a factory line, and they're put up in a 5-star hotel with swimming pools for a period of a week when the job takes 1 day, even though it is at or near an overseas work location, as the words that are found in the Act, is that a legitimate form of accommodation to take and to be included for the purposes of tax exemption? And it seems in the spirit of the law that that would not be the case. But how you draw those lines is a very difficult thing to do. And I wonder, the Minister may know the answer to that, what debate was had this time in the committee, and why these words were chosen, which seem very broad to me. This seems a very broad definition. It is simply at or near an overseas work location, full stop. And the cost to the employee for the accommodation, there is no specified time limit around it, or the reasonable estimate, and there is no specification of what type of accommodation. So that's my first question that I would appreciate a response from the Minister. The second one relates to 75D, which some colleagues have already referred to, the community housing trusts and companies aspect of the bill, and the shift from the words in subsection 1, replace a trust and its trustees or a company, brackets as applicable the entity whose activities are predominantly, end quote, with a trustee or company, brackets the entity whose activities involve, end quote. This is the shift from a trust being defined as something that predominantly does something to something whose activities involve. I'm trying to understand what the purpose of that shift was, because again, if that shift means that trusts who, say for a charitable purpose, want to house medical people in a community where they can't attract medical people because the accommodation is too expensive. This has been a debate that's been had before. Is that achieved? And is there an unintended consequence where trusts are also doing other activities which are not really in the spirit of a trust, for that purpose. Why has this been changed? There will have been a live debate, Mr. Chair, about that. Mr. Chair.
Dr. David Clark, fourth call.
Thank you, Mr. Chair. There will have been a live debate, I suspect, about that, if I'm not mistaken. What are the checks and balances, and how has the committee assured itself that that purpose will be achieved? The next area I'm interested in, and perhaps I should declare a personal conflict, the accommodation provided to ministers of religion. This old chestnut, it comes up every time in these regulatory matters bill in recent years, and the remedial matters bills. And let's remind ourselves, the purpose of this is to ensure, and excuse my voice is going, I have a cold. It's not an emotional response. Is to ensure that, as I understand it, and the minister can correct me if I'm wrong, that those small communities, often in hard-up places that have very few professionals left in the community, want to retain their Minister of Religion, because often in some small communities and remote places, the Minister of Religion will be the only person with a tertiary education, who has training in counselling, conflict resolution, who can witness documents and so forth. And for isolated communities, it is very beneficial to have that kind of person available, aside from the usual stuff that ministers of religion do in those communities, the hatch, match and dispatch, as it's called in the trade. Aside from the hatch, match and dispatch, having people in town who can perform those other more secular functions of witnessing documents, negotiating their way through disputes and so on, is what is being protected here. But the definition is the bit that I want to ask about, because it seems very broad. And I know that my colleague, the Honourable Clayton Cosgrove, may delve further into this, but on the surface, he was talking about it earlier, I certainly hope he will, I'll be disappointed otherwise. On the surface, it leaves it largely up to the religion itself to define who is in and who is out. Somebody whose duties are related mainly to the practice, study, teaching or advancement of religious beliefs. And what constitutes religious beliefs is, I guess, the fundamental question, and how broad is this category? Because we know in human rights legislation that we have a real issue again and again and again, where we have some kinds of discrimination, where there are exemptions for people who fall under a religious category. So the Catholic Church, for example, quite openly says it will not ordain women to the priesthood at this stage. And that doesn't sit neatly with our wider human rights legislation, and it creates problems at some level in our society. A conflict occurs that is challenging to resolve, and actually in this House we often are not willing to go near it. And here in this particular clause of the bill, we have the advancement of religion generally defined. I am wondering whether there is going to be guidance provided as to what constitutes a religion that is inside and what is outside the scope when we're talking about this accommodation exemption in clause, I think it was 82, on page 48, 49 of the bill. So I'd be very interested what the Minister has to say about the definition of that exemption. I can see he's studiously studying his papers, and I look forward to his contribution shortly. Thank you very much, sir, for the opportunity.
I call Kamal Singh Bakshi.
Move the question be now put.